So let's start with the title itself, How to Challenge a Will. That means that you are a troublemaker. When you want to challenge your will, there are an infinite number of ways in which you can do it. And since the title is How to Challenge a Will, very often you have to think like a crook. I can assure you that 70 to 80% of challenges to wills are bogus. It's very easy to challenge a will. It doesn't cost much. And I have noticed that it is a source of blackmail. I write a will and make beneficiaries A, B, and C. I die. A, B, and C ask for a probate. They want the share of my estate. Mr. D and Miss E decide that this is a good time to harass the life out of A, B, and C. 9 times out of 10, they will say the will signature is forged, the will was executed under coercion, the person was not in the right frame of mind. These are standard things that they challenge the will. And unfortunately, the court has to take cognizance of this nonsense. For all you know, it might be true. So until there is a trial, you never know what is the truth. So this is, I think, the best avenue for blackmailing people. What normally happens is they drag it on. Now, a person who dies is 70, 80 years old. Has children who are 50, 60, wants to distribute it to the children. Then somebody, as I said, Mr. D or Miss E comes in, challenges the bill, and it gets stuck in the court. Now remember, the children are 50, 60 years old. 5 years, they will make sure that the matter is drawn out. Normally, people think that court cases take so many years. It's not because of the judges. It's because of the evil intention of the litigants. They like to drag it on. Now, in a case like an estate, suppose I'm a crook and I know that A, B, and C, I'm D. A, B, and C have got something going for them. I may not be legally capable of getting anything. I'm fully aware of that I cannot get anything. But I will convert that. I'll explain to you how it works. Convert that petition into a suit. And I'll harass the life out of A, B, and C. Right now, I'm going through a couple of cases exactly like that. That's why I can speak with authority. Challenge the will, make sure that it is drawn out. The legal beneficiaries, after years, get tired, upset. They might even die, and their paper will have to be taken on record, which means another year or two of extension of the case. And you will find that finally, the real honest beneficiaries, the ones who are legally entitled to the estate, will throw in the towel and say, to hell with it, take what you want, at least give me something. It's a form of blackmail, and I'm surprised that the courts have not come down heavily on that. Any sort of blackmail like that, or maybe there might be another way out now that we're talking about it. Suppose an estate is worth 100 crores. No one goes in for 10 lakhs or something like that. Suppose the estate is worth 100 crores and somebody challenges it. 100 crores divided between 4 people, exactly, 25 crores each. One Mr. X comes in and says, I want my share. I am the 5th person. 20 crores should come to me. He blocks those 100 crores. Now, if he says that those 100 crores should come to me, the court should tell him, after, of course, a cursory study of the suit. I don't say the court should do it without thought. They should apply, the court should apply its mind. And after applying its mind, say that, okay, boy, so you need 20 crores, put 5 crores on the table or put 10 crores on the table. We want to see money where your mouth is. And if you are unsuccessful in the suit, this amount will be confiscated, whether it goes to the other legal honest beneficiaries or to legal aid or to hospitals or to schools is different thing. But you will lose that money. Right now, all that they need is maximum 3 lakhs. Maximum 3 lakhs, no more than that. And when estates are worth crores of rupees, obviously people can throw away 3 lakhs. So I'd be very happy if the courts came down very strongly. I mean, there are provisions for um, frivolous litigation, but nobody seems to be enforcing it. And in Maharashtra, this thing about frivolous litigation, you have to go through a process and take permission from the Advocate General to file a case against the person who has been disturbing, who has been rocking the boat. I feel that unless some sort of thing like that is done, we will have a lot of unnecessary, really unnecessary litigation. Estates are lying fallow. The law does not allow like it when the estates lie fallow. The law wants a property to be used and income. But then again, it will be in the court receiver's hand, or the money will be deposited with the court. The legal heirs to whom the money should have gone, the estate should have gone, dead. So if you are in this business of testamentary matters, I guarantee you that every alternate case will be bogus. I have found that almost all cases are bogus. So this could also mean another thing. If you draw up a will, think of what a crook will do to destroy the will. Besides the standard things like forge, I have a case where first it was mentioned that the will was executed under coercion. When we produced certificates from the witnesses, the story changed from coercion to a fraudulent signature. Now, if it's under coercion, obviously you say it's under coercion by the testator. Next day you say that it's not the testator's signature. Please make up your mind. But this is how cases are drawn out and honest beneficiaries are made to suffer. Registered wills also are challenged, all sorts of things. See, this is a free country, and one of the advantages of a free country is anybody can seek help from a court of law. At the same time, it can be grossly misused. So now, having started this, we would like the participants to really participate by asking questions, maybe drawing on their own experiences and exchanging thoughts. So will you please put on somebody who wants to get the thing going?
Sir, please put some light on the probate aspect because there have been contradictions in the court where I'm working. I'm not working in the provincial Mumbai, Kolkata, or Delhi or Chennai, but still some of the opposite parties they ask to get the probate done. So, is it really required or not?
Now, suppose you have 10 properties, out of which one or two are in Bombay or Madras or whatever it is. In fact, right now, I have a case like that. Most of the property out of Bombay, only one small flat in Bombay. So naturally, we got to go for a probate. Even though we have got an order from the provincial court for all the rest of the estate, which might be 95%. But for this one small thing, we've had to go for a probate. So maybe they are asking for a probate for property that is lying. Property means immovable property, which is lying within the city. That's a possibility. Just check on that before we shoot the fellow down. It's a possibility. Are you sure that there is no property in Bombay or Madras or wherever you are working, Mr. Milling?
Well, there is no property, neither the will is made in those areas.
No, just 1 minute. We're in a seminar. You can be open. Uh, what is the place you're talking about?
Alibag.
Alibag. Acha, chalo. Very good, Alibag. If the properties are only in Alibag, then there is no need to come to Bombay. If they ask you to take a probate, the only thing as I started with is trying to stymie distribution. They want to
Hmm.
harass the life out of you. So there are ways of doing it. First of all, ask them for simple thing is in court, ask them for a provision, stating that okay, you say I should go to Bombay, show me the provision. Worst comes to worst, ask for an originating summons as to what you should do. But as I said, it's a free country and people can harass the life out of you. You'll have to fight it out. I mean, the ones who come to court with these sort of things, remember, are ruthless people. They're in the business. Yours might not be the only case. They might be having two, three other matters also, exactly like that. Just come to court and say, take a probate. Of course, if the court has, see, there are two things which I always say, or by the three things. The first thing a judge should not know all the laws. I'll be happy if the judge does not know all the laws because it's the duty of the advocate to explain the law to the judge. A judge should come to the court with an open and clean mind. The second thing is the judge should have the courage to say that no, there is no need for a probate. Let's get on with it. If you want to challenge my order, go to the High Court and challenge the order, but no need for a probate.
Hmm.
The third thing is, of course, everybody has to be honest. So I always believe that if you have these three things in a judge, you get the right judgment, the right orders, and you are safe.
True.
I think you explained to the judge, tell him that, look, where is the need to go to the High Court? Where is the property within the limits of the city? If you've got only one or two properties, say that these are only two properties in Alibag. Now, what more do you want? You please pass an order on this. Most probably the court will do it because the court doesn't like to give orders which will be challenged and overturned. It's a
Right.
benchmark.
Right.
They have a point system also. So
True.
openly tell them, yeah, first of all, you ask the other party to show me the law.
Hmm.
Under which provision of law am I supposed to go to Bombay? I think you'll get away with it. Don't worry.
Okay. Thank you, sir.
Good morning, sir. The will done by a testator. The testator put up his will with medical certificate of the doctor, his family
Okay.
doctor, etc., with the mention in the will that I am leaving XYZ property specifically to the beneficiary, and the other of my relatives are not to receive anything. This has been mentioned very clearly in the will. And unfortunately, uh, two legal heirs, two sons. The property was left to one of the sons, not the other, who unfortunately has not yet executed the will under the excuse that he and his brother have very cordial relationships as of today, and there is no need to dilute or cause any disruptions in his cordial relationship. And so far, the other brother has not claimed any share in the property which is in possession of the son to whom the testator has bequeathed his property through his will. Now, in this case, sir, my query is it absolutely mandatory to have the will executed as soon as the testator is bereaved? And second, if such an execution is not done, will this be a detriment to the beneficiary to whom the property has been bequeathed through this will? If and at all ever such a stage arises, What would be your kind advice, sir?
Chalo. Well, let us start with one question at a time. First of all, before we start arguing the matter, probate of the wills, the faster you do it, the better it is. Don't wait. I have a
Okay.
matter where they waited some, it was wrong advice. There is no need for a probate. It was wrong advice. But because it was delayed, there are a lot of problems. Better to do it immediately. Who are the executors of the will?
Executor is the wife of the son to whom the property has been bequeathed.
Executor is the
Daughter-in-law.
wife of
So
the
to
son. Okay. Now,
daughter-in-law, yes, it is the
which,
testator's daughter-in-law who is the
okay, fair
executor.
enough. Uh, quite often, when the sons are erratic, they ask the daughter-in-law, who's usually more level-headed, to do it. It's a common thing. Uh, Tell me, is she one of the beneficiaries?
No, sir, he is not. The
She is
property has
not.
been bequeathed specifically to the son only
To
and
the
to
two
nobody
sons.
else.
To the two
No,
sons.
only to one son.
But I'm sorry, I may not have been very clear on that. One son, and the executrix is the son's wife or the other son's wife?
Is the beneficiary son's wife,
Then why doesn't she go
not the
ahead and
other
do it?
son.
Who's stopping her? Let the other brother raise hell. In fact, it is her duty.
Okay.
She's not doing anybody a favor. It's her duty as an executrix. It's her duty to get the will probated. The other brother might, for all you know, he may not even go to court. They're just trying to put pressure. But please advise her to go to court as soon as possible and ask for a probate. It costs nothing more than 75,000 rupees. I'm sure any property in Bombay will be worth a few crores. So you can spend 75,000 rupees. And originally, of course, if the executrix was a woman, where you didn't have to pay any money. But now you have to do it. So ask her to go ahead and please, the faster you do it, the better. In fact, now there are formats which makes the work of an advocate much less, though I don't think more intelligent. But you just got to fill in the blanks and file for probate. Please do that immediately and
Yes,
keep
sir.
the original will very safe. When it is called for by the court, take it out of the vault or wherever you have kept it and get the process moving. Let us see what the brother then wants to do. For all you know, the other brother might have already been given something much earlier, and that's why the father left him out. But let's go ahead with it. Let's go ahead.
Yes, sir.
Please. Uh, Mind you, you will have to give the other brother notice, whether he's in the will or not. You'll have to give him a notice that that the executrix will say that I'm executing the will, because it should not be done behind the backs of the relatives. Otherwise, they will say that there's something wrong with the will, and that's why they did it without informing us. If there are any other beneficiaries in the will, not for the property, maybe
Right.
for something else, please make sure that you inform them also. It is the duty of the executor or the executrix to inform all the people. In fact, just this morning, a paper came in hand, exactly the same thing, that I did not know that the executrix had given property. And from the papers that we were reading, I mean, I knew it was done, but how it was done, I did not know. So it is the duty of the executrix to inform the relatives. If there is, as I said, more than one beneficiary, to inform the beneficiaries. Maybe call them over and read out the will. That might be the best thing to do. Call them over, read out the will and say that, look, this is it. I'm getting a probate on this. If you have any objections, let us clear them out. But please, I mean, don't, if you find that everything is okay, let me probate the will in peace. That might be a excellent way of doing it. Say that you call your advocates over and we'll have a joint meeting. Call all of them to over at the same time. Don't call them one by one. Have a joint meeting, read out the will, and say that does anybody have any objections to this? For all you know, somebody might even elect out saying that no, I don't want anything out of this. Distribute it amongst the others. That could also be the case. So best is to have a reading of the will. Normally they do it. Normally they have a reading of the will. Bolo, what else?
Mr. Malcolm, there's a query on the chat box. What happens in the case a person makes a will and goes missing? So, do the beneficiaries have to wait for 7 years?
7 years. 7 years.
Oh, God.
Wait for 7 years. Ah, there's a very nice, and in fact, I've written about it 10, 12 years ago. Very interesting case. In America, a man goes missing. One day he just walks out of the house and nobody knows whether he's alive, dead, whatever it is. After 7 years, he's declared dead by the court. Whatever the process is, whether he had property or not is immaterial. But he's declared dead by the court. One day he turns up, maybe 10 years, 15 years later, and he goes to the judge. And the judge says, as far as I'm concerned, you are dead. I can't do anything about it. You are dead. What do you do then? Of course, if it's a will and it has been probated and after 7 years it has been distributed, even if the man is alive, there's nothing he can do about it. Because technically he was pronounced dead. He should have made sure that. But sometimes people lose their minds. I mean, not necessarily the day after signing the will, but maybe year, 2 years, maybe an accident, head injury. He might start wandering off somewhere. After 7 years, maybe he recognizes the place and comes back, or a bit of his memory is restored. Anything can happen. But after 7 years, please go ahead and have it probated and finish the matter off. Then we'll see. If he comes back later on, we'll see what to do. Bolo.
Okay. The next question: how does both testamentary and intestate succession take place of a person who is of unsound mind?
Who are those witnesses who were present and signed on the will of a testator who is of unsound mind? First of all, let's get that question done. How can you prove that the man was not in his right mind? Like that whiskey story. The testator's final proof, what they say is gospel. That is why I said I get the affidavits done within a year or so of signing of the will, just in case the witnesses die. Now, suppose the witnesses die. The first thing people will do is challenge the will, saying that he was not in his right mind, coercion, this, that, and the other. Because there are no witnesses to say otherwise. Maybe now that the thought comes to mind, if both your witnesses die, just as your executor might die, your executrix might die, please prepare another will. Override, maybe identical to the one that you had executed before. But please prepare another one with new witnesses, maybe the original executor, executrix, new ones, whatever it is. But if your witnesses die, I think it is in your interest to write another will immediately. Because where are you going to get the affidavits that the court wants? Yeah, I think it's the safest way. No other way out. No other way out. I'm sorry. Bolo, what else?
Sir, my simple question is I have property in Mumbai as well as property in UP. So where should I file for probate?
UP where?
UP near Farukabad.
Near, not in a not major. Bombay.
No.
Please do it in Bombay. You are seated in Bombay. You see, you might have
Yes.
properties all over the country, 100 properties. One property in
Yes.
Bombay, please do it in Bombay. You are allowed to see if you have a property in Bombay and Calcutta, you have a choice.
So I can include that UP property also, right, in
Yeah,
my
yeah, yeah.
schedule?
What do you mean? Can you have to?
Okay.
Whether you
Okay.
like it or not, everything must be declared to the court. Please don't hide anything. In fact, there is a table where you have to mention all the assets and the total assets. So please do that. Don't hide it. Otherwise, there'll be another problem, and you will be
Okay, sir.
responsible for giving wrong advice.
Mr. Malcolm, there is one question. Can a testator make different wills for different properties?
Different wills. You are asking for trouble. See, if you make different wills, the last will be valid. The ones that you made before are dead. The piece of paper, tear it up and throw it away. In fact, you should tear it up and throw it away. If you make a new will, please tear up the old ones. Otherwise, they'll keep on popping up and there'll be a lot of confusion. If you don't want to tear it up and keep it as a record, scratch it out, write cancelled in your own handwriting and say cancelled. But please don't keep many wills floating. There'll be confusion en masse. Nothing will ever happen. You'll be fighting cases for 100 years.
Okay, now this is a question related to Hindu undivided family. In case the Karta dies and makes a will devolving the property only to one co-partner, so can other co-partners challenge it, or the will is void?
I'll call Divya in. She's the right person. The matter is what property? Was it acquired by the Karta himself or was it ancestral property? That's a very important question in Hindu law. When there's, or was there a partition earlier? All sorts of things. I mean, the Karta can't will away ancestral property just because he likes to. But it might be his own property which he wants to give away to somebody. No one can stop him. I'll just call Divya in. Just hold on, please. Ah, she's here already.
Yes, in fact, in law college, the first amongst the first topics that we study is our personal laws, and I found it extremely fascinating. The Hindu Succession Act, all the Hindu laws. I when I started reading them, I said, "Oh, really? Is this how things work?" At that the law has changed quite a bit in the last few years. I mean, I've read last 15 to 20 years. In a HUF property, first you have to establish that it's an HUF property. Earlier, HUF property would devolve only on co-partners. Now, as we are becoming more individual-based society, HUF, if you have an interest in an HUF property, you can will away only your undivided interest in the HUF property. The rest of the HUF property, so typically in a house, HUF house, everybody would have a share. Your uncles would have a share. You would have a share. The eldest uncle would probably be the karta. So your share, and that is determined on an assumption. So if there is no partition, then your share, how do you determine your share? Your share notionally is that undivided interest which would devolve on you if they were partitioned by metes and bounds. So that interest you can will away. Karta has the control of the entire HUF property, but that doesn't mean he can will away the whole of HUF property to one favorite, because everybody has an interest, including the girls, the women. See what has happened now. The Law Commission is having a rethink. Women have been given the same status as a male co-partner, to the extent that they can even become karta. See, Maharashtra, when it amended its laws, when Hindu Succession Act in Maharashtra was amended way before the central pan-India amendments came in. So the only difference is in Maharashtra, women had equal rights, but thanks to the amendment, now they are going ahead and clarifying that even women can be kartas. The backlash is that women are now getting interest in their ancestral property. They're also getting interest in their father's in-laws property as the wife. So whereas men are at a disadvantage, firstly, if you're a father, and if the son passes away, then father is a class 2 relative. Father in the Hindu law is not class 1 relative. So everybody gets a share except the father. So that is one thing that the Law Commission is looking at and wanting to change. So yes, the Hindu undivided family can be willed away, but only the individual's interest can be willed away, not the, obviously, you cannot will away something that does not belong to you. That's the first thing. And how to determine what your interest is, as I said, you have to take make a assumption that there is a notional partition, and how much would you get if there was a notional partition, and accordingly, that undivided interest you can always will away. Frankly, Bapu in his wills always has a residuary legatee. It's very important for you to know name a residuary legatee, and I think Bapu can elaborate on the concept of residuary legatee, because the laws change. You never know what further property you may acquire. Somebody might inherit. Somebody might will. You may, before you die, you may have got an inheritance which you are not aware of. So we always put a general clause that for things which are not specifically mentioned in the will, there is a residuary legatee who will inherit all that which is not specifically mentioned.
Thank you, Divya, for your insights. There is one question: can a BMC slum room be bequeathed through a will?
I believe that any redevelopment for 10 years, you can't sell it, but that doesn't mean you can't bequeath it. It's yours. Anything that's yours is, it should, I mean, let's look at it with common sense. There's a slum development. I'm one of the slum dwellers. I get a flat. Tomorrow I die. Should my children be out on the road? Of course not. So whether you bequeath it or not, by succession, they will get it. I mean, it's just common sense. You can't throw people out. But for 10 years, you can't sell it. That I know. What else?
Next question: can you shed some light on provident funds? Because there is a testator who had properties in Uttar Pradesh and the provident fund account in Mumbai, and now the court is asking to get a probate from Bombay.
Only
I think the
provident.
provident fund company is asking to get the
They
probate from
will
Bombay.
see if it's a provident fund, public provident fund, or with the company. He's been working somewhere where the provident fund might be, and he must have nominated somebody. In short, these days everybody asks for a probate. Well, they don't understand the meaning of a probate. You go to the bank, you are the nominee, you are the joint signatory, but because the other person has died, get a probate. I don't understand. If the will is intact, they should be courageous enough to act on the will. And it's only meant for the immovable properties, not meant for everything else. Only in Mumbai that we had discussed. We had discussed. So they just insurance. They'll say get a probate. Why? Sometimes you'll find people who are well versed and who will take a decision. But see, the idea is to put things off, not take a decision. By the time they start fighting whether it's a probate or not, the officer gets transferred. So it's off his head. Nobody wants to take decisions. That's the whole problem. And nobody teaches them what to do, what the correct law is. If they could do that, a lot of problems would be solved. But if there is property in UP and there is a provident fund here, you can file a suit anywhere. I mean, file proceedings anywhere, whether it is in UP, whether it is in Bombay. Only thing is, please inform them of all the assets. Don't hide anything. That is murder. Your murder. You'll be get into serious trouble. Don't hide anything. A lot of people do, but please don't do that. And there's a list, you can just write it down, this, that, and the other, and go to the court. At the most, what will the court say? I have no jurisdiction. Then you can challenge that, whether it has a jurisdiction or not. We don't know. In fact, Mr. Yadav will bear me out on this matter of jurisdiction. Whether the High Court has the jurisdiction on testamentary matters or the city civil court. I was speaking with the judicial registrar 3 days back, and he also confirmed that I was right. The city civil court does not have jurisdiction. Only the High Court has jurisdiction over a probate. But as far as provident fund is concerned, frankly speaking, once you give the death certificate and make an application, the money should be transferred. There could also be a possibility that these days they are not transferring public provident funds are all this because there's a shortage of funds. The more they delay it, the easier they'll be able to get out of the hole. That could be one of the reasons that they are delaying it. I mean, it's always easy to say no, it cannot be done. And then you have to prove that it can be done. By that time, situations change. That could be a possibility. But there is no compulsion. Okay, next question.
Okay, the next question is, can a will be challenged if will mentions that the proceeds from insurance claim shall go to person A and the insurance contract has appointed person B as the nominee?
No, there's an insurance policy.
Yeah.
There is a nominee
Hmm.
and somebody else in the will. Of late, all the judgments that are coming, especially out of the Supreme Court, say that will overrides everything. Will overrides everything. It's mainly because of the problems of flats. People make nominees and leave the flat, especially in cooperative societies, to somebody or the other. The nominees lay claim to it. And the secretaries, maybe even the managing committees, are creating a breach by transferring it to a nominee. They have no right. In fact, nobody except the court has a right to transfer immovable property. Full stop. The nominee in this case of societies, as I have mentioned 100 times before, is nothing but a bridge. The nominee has one big thing in his or her favor. That is the privilege of paying the society until the will is settled. The society wants somebody that they can catch hold of to get the society's dues. Otherwise, people will say, Abhi probate mein pada hai, I cannot do just now this, that, and the other. It is the duty of the nominee to make sure that the dues to the society are fulfilled until such time as the true legatee is decided by the court. So this nomination thing, originally, of course, a nominee in a bank would take the money out, whatever. But of late, the courts have said that a will overrides all nominations. The best thing to do in this case is, I mean, if the person is wanting to, there are a lot of people who give nominations left, right, and center just to get something out of their relatives. Anybody comes, हाँ बेटा तुमको nomination देगा, हाँ बेटी तुमको nomination देती हूँ, that sort of thing, just to please people. But the best thing to do is to make sure that the nominee is correctly mentioned in the will. Say that if you have a bank account in XYZ bank number so and so, number so and so, that account for there's a nominee and it should go to the nominee himself or herself. But now suppose there's another thing. Suppose you are a joint owner of the account. Say my wife and I are joint owners and we keep another nominee. In fact, the banks are insisting on nominees these days. Everybody wants a nominee. I keep a third person as a nominee. I die. What is there to stop my wife from operating that account and taking the money? Why should the nominee interfere? The nominee could interfere if both of us are dead. But then the nominees insist that no, this money is mine. I'm the nominee. At least half of it is mine. These are problems which have to be sorted out by making it very clear in the will. And please tell your clients not to go around issuing nominations left, right, and center just because it doesn't cost them anything. They could create a lot of problems. I think in shares recently, I think in mutual funds, you had to have a nominee. And um, Sucheta Dalal of Money Life had taken it up very seriously. Said, what is there to say that I must have a nominee? I don't want to have a nominee. What are you going to do about it? I don't want a nominee. So if they insist on a nominee, you'll have to put in a nominee just to make your life less miserable. But make sure that the nominee is the legatee also, that there's no problem. And a joint account. See, there's another thing. Joint account operated either or by two people, any of the two. One person dies. The next day, withdraw all the money from the account because you have a right. They might say that you should have informed us that the other person is dead. But take the money out because then the nominee will not write, nor will the bank play hell into you by saying, get me a probate, even for money lying in the bank. Best thing is to withdraw it, finish it off. Then let the bank decide what to do. Otherwise, as I said, make it very clear in the will. But then the banks also have, anytime you take a will to them, the first thing is a probate law. Don't you understand that this is money? There's no need for a probate law. They want to push the responsibility away from themselves. Unless, of course, there are officers who. Yesterday, I was at the bank and I went to a wonderful officer. He guided me so well, took all the decisions, took all the responsibility on himself, said this, that, and the other. And after I finished this seminar, I'm going to the bank because I want to finish it off. He's told me to come and finish. You might find people like that. Bolo, what else?
Hello. I have a question regarding the probate part. If the contents of the will, whatever immovable properties that are mentioned, are not present in the metro cities, let's say whatever Mumbai, Calcutta.
Just 1 minute, Mr. Vatse, no, Mr. Vatse, just a little bit slow. I find it difficult to understand things which people they speak so fast. One question at a time.
Yes, sir. The contents in the will mentioning the immovable properties
Immovable property.
are present outside the metro cities.
Yes.
Yeah, and even the will is also registered in outside metro cities, in the Gram Panchayat area,
Okay.
in the Maharashtra state.
Okay.
So, is the probate compulsory at the?
No, I mean, like, you don't have any assets in the city. Why do you think of the city? Go to your district court and get it done. There is no immovable property in the city, Bombay, Madras, etc.
Okay.
Calcutta. Just go to your district court and get it done. They'll give you airship certificate and finish it off.
Acha. Okay. Yeah.
In fact, it might be a lot cheaper also over there. Anyway, let's come to the topic that we started with. I know everybody has a personal problem which we talk about all the time. We were talking about cheating, frauds, how to challenge wills. Let's come back to that. Ask me a few questions on that because these days every will is being challenged unnecessarily. Every will. People just go to court and challenge wills.
There is one question. Can a will be challenged if the testator was not in good terms with the executor or the beneficiary?
I'll give you an example. Of course, I can't give names. Two executors. One executor sells off the property, God knows why price right or not, and then recuses himself. He says, I don't want to execute it. The other executor may or may not be able to do it. What then? Best thing to do is to ask for letters of administration, let the court decide what to do. Because once the court decides what to do, no one can challenge that. Malvika, I'm only
Yes.
answering half the question. What was the other half? Read out
That's it.
No, read out the question to me again, please.
So I think the participant wants to ask, in case an executor or a beneficiary is appointed in the will and the testator during his lifetime did not have good relations with them. So can a will be challenged on the ground that the testator can no way appoint this particular person as an executor, or the property cannot devolve on to that beneficiary because the testator did not share good relations with them?
This is a personal thing. Um, we had made a will. I had made a will and appointed executors. Unfortunately, later on, I was unhappy with my choice. Very unhappy with my choice. I had to make a new will. I had to make a new will with new executors. The best thing to do in these cases is please make one of the beneficiaries or maybe two of the beneficiaries or more of the beneficiaries executors of the will, so that a third party cannot either blackmail you. There are executors who do that. They will blackmail you. They'll say, I'm not going to execute the will. मेरे को इतना पैसा दो तो नहीं तो करने वाला नहीं हो. What do? Very often the will is left with the executor. When you make a will, if you have 5 beneficiaries, please make 5 copies and give one to each of them. Say that please don't open it until they will of course open it. Nobody likes to keep it secret until I'm dead. Please. So each one knows and make them executors. So that if one of them or two of them don't want to execute the will, the others can do it. And when the others do it, suppose A, B, C, D are executors, and C and D are chary about executing, make some sort of a nuisance of themselves. Go to the court, A and B, if you are A or B, go to the court, ask for the probate or any other form of execution, and send notices to the other two, C and D, that you are also executors. What are you doing about it? They'll have to come to the court and say, we are not interested. They can't obviously come and say, okay, we are going to blackmail these people. But they'll have to come to either recuse themselves or act as they should. So it's always better to make the beneficiaries also the executors. I think people have an idea that you cannot make an executor, a beneficiary an executor, but that is wrong. In all our wills, we make sure that at least one or two of the beneficiaries are also made executors, so that the beneficiaries are not subjected to blackmail. Now, suppose I'm an executor of a will, sole executor. Person dies. Millions of rupees should go to the children. I bring up some story or the other and avoid going to the court and harass the life of the children. Finally, I say, chalo, karna mangta hai, I will do it. But I mean, grease my palm, otherwise I won't. Now, without saying it, what do you do then? Make the beneficiary also an executor of the will. Okay? What else?
Have you ever experienced your will be challenged on the basis of the aging of the paper on which the will was executed? Like the will may have been dated XYZ, and after several years, one of the relatives would go to the court and say, you know what, this is a forged will, this document is not proper. You see the paper, see the date, and we request the court to put the paper on which the will is written to the forensic evidence. Have you ever experienced something like this, sir?
My grandmother's father had written these sort of things. He had written it on some sort of paper, and after a few years, it could not be read. It was garbled. It was a mess. Some 50 pages of handwritten will, and the family had to go to court and say that look, and even the court could not make anything out of the will. So it was considered intestate. If you can't read the will, it becomes intestate. But what can you do? Now, if suppose I make a will when I'm 80 and I live to be 100, obviously that paper is going to it's going to go into pieces, it's going to become powder. So it's in my own interest to make another will, maybe when I'm 50, maybe when I'm 80. It's in my own interest to do it. So normally this sort of thing doesn't happen, but it could. And if you're the will, see a will which cannot be read or which is on bad paper, it's no paper, it's no will, it's nothing, absolutely nothing.
I agree with you, sir, on these points that you have mentioned about the unreadability or the deteriorated paper. My query was like, for example, a will was written in 1984, perfectly legitimate, properly typewritten, proper green ledger paper, etc. Now, the date of the will was 1984, and after 17 years, one of the relatives came back to the court saying, you know what? Look at the paper. This paper is recent and the date on the paper is 84. Don't you think that this requires forensic change? Is this a valid argument? I mean, does
I
the
am,
court even entertain these kind of petitions?
sir, it happens, and I can give you a personal experience. Of course, as I said, I will give no names, but this sort of thing happens all the time. I was standing outside the Central Bank of India one day, waiting for my wife to come down. A colleague of ours came along, and of course, with my age, they would call me Bapoo uncle. So we exchanged greetings, and I asked him, I said, "What are you up to?" He says, "I have come, now listen to me very properly, an exam for the judiciary." He wanted to become a judge. I said, "Good, good luck to you." We talked. Then he tells me, he says, "Bapoo uncle, I've got a problem." I said, "What is it?" Now, standing on that corner, you can see the State Bank of India, 150 meters away. He tells me that there is a locker in that bank belonging to his grandfather, and it has not been opened in 50 years. What should he do? I said, go to the court. If you want, I'll go to the court. Get a court order, open up the locker, make a list of things that are in the locker, and then we see what to do. And I said, I'm pretty sure that for 50 years, if you have not paid for the locker, the bank itself must have opened it. But whatever it is, you know what he told me? There is nothing in the locker. Can I make a duplicate will? This is gospel. I'm telling you the truth. Person appearing for the judiciary examination asks me that very evening whether a forged will can be made. My first question was, how would you do it? Of course, my first question was this. I said, if you ever become a judge and I happen to be in your court, please recuse yourself immediately, otherwise I'll bring this story up. Be careful. So I said, he told me that he knows somebody who has preserved inks and paper from way back and that it could be done. I know for a fact that old um, typewriters are kept, old papers are kept. The older it is, the more money you have to pay for it. But I'm telling you, forgery is being done on that basis. Of course, if you are careful and good forensics, nobody can get away with this sort of forgery. But you have to be very careful, very diligent in pointing out that it's a problem. It will take time. It will take time, no doubt about it. But remember one thing, all crooked people always make mistakes, always. There is some flaw or the other where they make a mistake. Just one small flaw. I am sitting here in this big house. All my records were destroyed because I was out of Bombay, as if I did not exist. But as it was my habit of reading, I had an envelope as a bookmark in the book that I had taken out of Bombay. And from that one envelope, I was able to prove that not only was I staying here, but the person who said that person was staying here was actually staying somewhere else, only on the basis of one envelope. So they will always make mistakes, but it's for you to find out what the mistakes is. It's like people lying in court. They come to the court and lie through their teeth. But remember, they'll always make a mistake. It's your duty to find out where they have mistake, where they have made the mistake, where have they lied, and point it out to the court. But this thing about old paper, this, that, and the other, it's a common thing. I'm sorry, but that's the way it works. One more thing. When you said old paper, this, that, and the other forged, what exactly were you worried about? The exact.
I think Mr. Malcolm, he meant to ask, today I write a will on a paper which is say from 1980. So will it be challenged?
I can write on paper which is 1900. But
Hmm.
that is why when I write today and two witnesses sign. Obviously, the two. See,
If I may
the
speak, sir.
built-in checks and balances in everything. So that person has to be alive to sign the witness.
My question was, sir, the will was actually written and properly registered in 1984.
Then what is the
The
problem?
date, etc. on the will showed as 1984, but then in 17 years after the will was written, one of the relatives came into the court with a petition that we have come to know that such and such will was executed by that
Boss,
testator,
boss,
but that was a forged will, etc.
boss, you have registered the will. You have registered the will in 84 or 85. No, no, as I said, people will come up with all sorts of stories. And it's for the court to come down heavily on people like that. Unfortunately, the courts don't. They should come down heavily on that. You said that it is signed 17 years later, prove it. And if you can't prove it, I'm going to fine you. You
Right,
can't
sir.
just come up and give the court any story, a cock and bull story, and say that this is it, this is it, this is it. You're wasting the time of the court. To run a court costs money, lakhs of rupees every day. Think
Exactly,
of
sir.
the staff,
That was
think
my
of the
question.
maintenance.
That was my question.
Yeah, yeah, go
So,
after the fellow if somebody. I hope it's not your client.
yeah. So the question was that, sir, does the court, in your experience, does the court even entertain such petitions?
God has to entertain it. Even if you get anticipatory bail, that doesn't mean you're off the hook. The trial continues. Only thing is you are out of jail. Very rarely will it be quashed. It is the duty of the court to listen to everything and read every piece of paper that is put before it. That's the torture that a judge has to bear. He has to accept papers, he has to read them, he has to take a decision on that. Can't just summarily say, get lost. It's not possible. It's not possible.
Understood, sir.
You
Thank
might
you so
want to
much,
do
sir.
it, but it's just simply not possible. For all you know, you might be wrong and the other person might be right. Let the judge decide. Who are you to decide? You can make an application for dismissal. You can make an application for discharge. You can make an application for whatever you want. The court will listen to you. Court will listen to the other side and then take a decision.
Right, sir.
But
Thank
this
you so much for your
17-year
valuable
story,
time, sir.
that the court will throw it out. The court won't listen to it. Bolo. What else?
Mr. Malcolm, last question. How much time do petitions relating to challenging a will take for reaching conclusion?
Malvika, I
Hmm.
have done petition bills. In fact, one case where there was no executor, where a lot of problems. To tell you the truth, we took a year and a half to make up the case. The client, fortunately, was extremely honest, which is a very rare thing these days. Clients don't tell you the truth. Every client has something to hide. And hiding things is as good as lying, maybe even worse. Very helpful. We got an order on the very first day without having executors. On the very first day, I can give you a citation also for that. On the very so it all depends on how you go to the court. Prepare yourself very well. Prepare yourself with every eventuality and think like a crook. It is your business to think like a crook. You have to think of all the possible impediments that people will put and make sure that your case, in fact, including the will, when you're preparing the will also, it is the duty of the advocate who's preparing the will, duty of the lawyer who's preparing the will, to make sure that if it is challenged, how that challenge will be met. Just making a piece of paper and getting a signature, you might be inviting trouble. And to tell you the truth, making a good will is 100 times more difficult than filing a plaint or a suit or a complaint. There are so many variables, so many options available. And then, of course, the testators keep on changing their mind every day. You give this to them, give that to them. So that's another problem. But you have to be very careful. It's a complicated process. At one time, I used to tell people that please make your own will. There's no need to go to a lawyer. But over a period of time, I have realized that I was completely wrong for two reasons. One is clients are not honest. If they're not honest with you, they're not honest with themselves also. So if they make their own will, they won't be honest in that. I have known of a person to make a will and include property which was not his. Really. So people are not honest. And the second thing is that they cannot think of all the possibilities because their mind is focused only on one thing. It is for the lawyer who's helping them draft the will to think of the possibilities, ask questions, solve problems, and either put them in the will or remove them from the will. As I said at one time, I used to tell people, make your own will. But now I've changed my mind completely, because unless you know the law and you're extremely honest, appoint a lawyer. It doesn't really cost much. When you've got property worth crores of rupees, what's a few thousand rupees? Bolo. Or anything else?
Sir, my question is in a property which is a joint property, family-owned ancestral property owned by many people, many relatives have a stake in it, and the executor has said, okay, this whatever part of it I'm occupying, I'm willing to somebody else. I'm giving it as a will to somebody else. That seems incorrect to me because it is one undivided property. Entire building is one undivided property. I am occupying maybe a portion of the property as one of the occupants, one of paying rent also, because it is, although I'm an owner, I'm also paying rent.
You can't be an
So,
owner and a tenant.
no, sorry.
You can't be an owner and a tenant. You have to decide whether one of the two.
No, you are a owner because you inherited the building,
Then you can't be a tenant.
and along with other people, and you are being a tenant of the
Maybe
particular premise that you are occupying.
let us call it a contribution instead of rent.
Okay.
Let's call it a
But
contribution.
can I will my portion, the portion that I am occupying, can I will it to somebody?
Your first sentence, and I think Professor Rajadaksh will remember how we had sorted this out. You said joint ownership. There is a difference between co-ownership and joint ownership.
Okay.
My simple explanation while teaching this variation is this. Take a very expensive portrait, something worth crores of rupees. It is jointly owned by you and me. If one of us dies, can my relatives ask you to tear it up? Jointly owned, it comes to you. If you die, it comes to me. So there's a very fine line between joint and co-ownership. In co-ownership, you divide it. But can a portrait be co-owned? It cannot be. It's impossible. Technically, it's impossible. It has to be jointly owned. So when you said first joint property, person dies, the other joint holders become the owners. Then you could
Sir,
ask me, second person dies, third person dies.
yeah.
Finally, it will be left with the person who survives.
Okay. No, sir,
That
what
is
I
the
meant
idea of
is,
joint ownership.
this is a property which my grandfather owned.
Yes.
I mean, built and then it went to my father, and now it has come to the various brothers and sisters. And one brother, which is occupying a certain portion, has left a will saying that that particular portion which he is occupying, part of the building, can be sold and the money should be distributed to some friend of his.
No, I cannot believe that can be done. If it is joint property, ancestral property, you can't induct anybody else. You can't even get
Okay.
somebody else to. It
Also,
will break up the family. No, it's just not possible. I wouldn't do it.
yes, sir.
I
Sir,
would
I
not.
have another
One more thing. One more thing. I would suggest that if that relative of yours, your uncle or whatever it is, wanted to leave some amount to his friend, if all of you have a little bit of money to give to the friend, just pay him off. Maybe his friend was in need. Pay him off and finish the matter. Ask him for a release. That might be a better way than fighting it out in court.
Okay, thank you for
Just,
that.
just
I
one
have
more thing.
another small question. In the same will, the person has put two executors, and only one executor has applied for probate. And in that probate, the other executor has declared that he is withholding his right at the moment. Means he is keeping his right at abeyance for the probate. I was wondering what is the advantage of doing that.
I'm also wondering what is the advantage of that. He must be wanting to make up his mind. That's when he became the See, another thing, yes. Now, since you brought this up, ask the executors whether they are willing to be executors. And I write in my will that I am appointing so and so as executors. And I have the permission to do it. I have talked to them and they have agreed to be executors. And another thing which is very important is give them permission to appoint other executors. Now, suppose you have two executors, one dies, the other becomes incapable of going to court. Please make a provision for them to appoint other executors so that the will is not. Otherwise, you'll have to go in for letters of administration. So they can appoint other executors who can do the work for them. I had become executor of my auntie's will primarily because she had made her brother and some relatives executors, but they could not do it. So because there was a provision in the will that they could appoint another executor, I was appointed. Of course, the will was drawn up by a legal giant, Girish Bhai. He knew exactly what to do. But this thing escaped many people. And this could also be a problem for
No,
one executor. As I told you recently, one executor sells off everything and then goes away and says, I'm recusing myself. What happens?
yeah, no, sir, both the executors are also beneficiaries in the will.
But then in
Substantial
that
or
case,
substantial
go
amount.
ahead. Go ahead. If the fellow has given you a letter saying that I can't make up my mind, go tell the court that this fellow
No,
is making it.
what the other executor is saying is that in the probate, the other executor has given a document saying that he is holding himself back
No, no,
and he reserves the right to file again for a
he
probate
can't,
later.
he can't. If they're trying to play around with the court, ask the judge to call the fellow to court and fire him. What nonsense is this? I mean,
Right.
uh,
Yeah, it seemed to me as though if the
uh,
first executor loses the case or something, this fellow is like a backup
give him
executor.
notice. Give him notice. Give a court, summon him to the court. If he doesn't come, send a warrant. अरे वैसा आदमी लोगों तो nothing will get nothing will work if you have
Yeah,
people
no
like that.
conclusion. Yes.
And
Thank you
think
very
of the
much, sir.
courts.
Thank you very much.
Think of the courts. They would be. The judges are not there to play games or be part of games.
Correct. Thank you, sir.
Okay, Mr. Malcolm, thank you so much for such an engaging and such an informative webinar.